everybody. Thank you very much for joining me tonight for the legal aspects of starting a business. Learning about legal stuff is always entertaining, so entertaining, but I hope I can at least impart some wisdom tonight that will help you in your business. I'm Terry Traveland. I am a volunteer at the Small Business Development Center, and I've been volunteering there for a while. And if you're wondering here, I'll address that. Yes, I was a stupid person and tripped while walking my dogs and ended up with a broken finger. So sorry about that. It's really fun typing with 9 fingers lately, much slower. Anyway, if you will look in the chat section, if you'll pull up your chat box on Zoom, there is a link that will take you to documents that I don't know if she's emailed them to you or not, or if you just got the handout for this, which is our PowerPoint presentation. Typically, I hand out certain documents throughout this class, and so sometimes she forgets to send those. So I've provided a link to those for you so that you can download those as well. There's a special treat for you, which is a legal agreement that you can use in your law or in your business, and I will explain towards the end of this class how to use that and how to apply that in your business. So make sure that you do download those. Now, let's get started. So one of those handouts that is with the link, oh good, they are at the email. Oh good, so she did email all 4 documents to you. That's great, I'm glad that she did. Thank you so much. And by the way, for the chat box, because this is very different than teaching in person. So if you have a question for me that is a clarification question, put it in the chat box, and I glance over there occasionally and we'll see it hopefully, because it's just off to the right here. If, however, you have a question that is more specific to your business, and the way that you'll know that you have that type of a question is you have to give me facts in order for me to answer the question, right? It's not a clarification of, you know, I don't understand this, or can you repeat that, or can you explain this? It's more of a, so if I was doing this, or if my business was doing this, then what? If you will save those to the end, just write them down when you think about them, and then save them to the end, and I will stay and answer all your questions via chat. Well, I mean, I'll answer them this way, but you can put them in the chat, or you can go and unmute yourself at that point and ask them that way, and I'll be happy to answer your questions for you. So hopefully that will help as well. Okay, so let's see. I have been practicing law for a long time. Here, let's see if I can get this to go. Nope, apparently not. We'll do it this way. Really and truly, I sort of know how this works. I can't get the screen to advance, but I can do it here, I think. Maybe. Wait, no, I can't. Excuse me just a second. Let me get my IT guy. Hold on. Hey, Derek, the thingy isn't working to advance. Oh, yeah. Apologize. I don't know what button I was supposed to push. There you go. There. Okay, it didn't work. So, okay, thanks. All right, got that done. Sorry. Technical glitches. We're still ironing out how to do all these Zoom things, and I know y'all are probably doing the same as well. So please bear with me as we get this correct. Anyway, so I've been practicing law for a long time, 26 years now, almost 27. I am a large firm trained attorney, which means I practiced in the largest firms in the world for about 8 years. And then that's like 15 years of experience condensed down into 8. And at some point I decided I really liked sleep and I wasn't getting any. So I quit the week before 9/11 and started my own practice. I work with entrepreneurs and I help them start and grow their businesses. So I'm also an entrepreneur myself. I'm a very successful client, or I'm a successful client of the SBDC. I started a chocolate business and built it up. What had the chocolate in the gift bags at to the presenters at the Oscars. And then a couple of years after that, sold the business for the intellectual property in it. People said, well, why would you do that? Why would you sell your business? I'm like, because they paid me money and I can start any business I want, which I did. After that, I ran a member site for 5 years. So, you know, I do that between 2 and 4 in the morning. Type A personality, always busy. Anyway, so that's really kind of my background. So I definitely have a business background and a legal background. Now, when I work with SBDC clients and any entrepreneur, I come across several things. First is that most entrepreneurs don't understand just how much capital it's going to take in order to become successful, right? They don't understand their burn rate. That's how much money is going out before money comes back in. And then how much money goes out after that as well, because your burn rate is how much money goes out each month kind of thing. And you want to be able to understand what that is. So if you look at the documents that were sent out and also the link, there is an article on the 14 reasons businesses fail or fail to thrive. And one of the reasons in there is a failure to understand your capital requirements. And so you really need to get a handle on those. And that's what the SBDC can help you with. They can help you understand what your expenses are. They can help you understand that you need insurance and what type of insurance and what the cost of that insurance might be. And if you need suppliers, they have databases that you can go and search. And, you know, if you wanted to search them or pay for them yourselves, it would cost several $1,000s, but they're free to you to use as a client of the SBDC. They'll teach you how to use them, and then you can search and find what it is that you need. That's how I found my chocolate suppliers for my chocolate maker and my chocolate manufacturer to make the recipe for us and then put the chocolate into bars for us. It was a quicker way to get started in my business, and then also to grow the business without having to buy all this manufacturing equipment that's really, really expensive. So I did private labeling that way. Also, like one of my clients was about to pay $1,000 for 250 leads. And they thought they were getting a bargain. I said, let me see what I can do at the SBDC. So the next time I was up there, I asked a counselor to help me. I did a quick search of one of their databases, and within 15 minutes, I had probably 3,000 leads, good leads for sales that I could give to them. And it had the company name, the address, who the contacts were, the phone numbers, how large the company was, what their annual sales were, a lot of information all in one database that was so helpful for them to go out and try and sell their product. And that was free as well. Not only that, but because I had spoken to the counselor about what was needed, the counselor went in and said, let me see what I can find. And he found for me a white paper on this specific industry that my client was in, so that when they went to go look for investors, they could answer questions about what was the state of the industry. Is it in a growth stage or not? And, you know, they had been getting feedback that it's not, it's in a declining industry, but the white paper proved that it was a steady industry, but their specific niche was growing like crazy. So that helped them to get funding for their business, because they could prove that they had a viable business that was in growth stage rather than something that's just going downhill, right? So those are all things that the SBDC can do. Plus, you can meet with a counselor and you can get help on drafting your business plan, your marketing plan, get ideas on things. You can discuss problems you're having. All of that. Now, are they going to do the work for you? No, you're going to have to draft your own business plan. But what they will do is look at it and issue spot for you and make suggestions on how to improve, or, say, well, wow, like I often do this. I'll look at it and go, oh, okay, so your revenue model is this. Have you thought of this revenue model? Because you can make a whole lot more money on that, or it would be easier for you, or whatever it is. And we can suggest different revenue models, different ways of doing this business, and really help you to grow your business. So I highly recommend becoming a client of the SBDC. You do that by going to callinsbdc.com and applying. Now, don't be offended if they say, oh, you're not ready for us, and they send you to SCORE. That's okay too, because the SCORE is the Society of Retired Executives or something like that. And they are great volunteers who have been there, done that, and have the t-shirt and are willing to help and ready to help entrepreneurs succeed. So, that's a good resource for you as well. The reason I say this is because what takes down a business is what you don't know, and you don't know what you don't know. So that brings me to the second point of what I want to point out in that article, which is you will hear a statistic that says, and it's anywhere, they'll say anywhere between 75 to 90% of the businesses that are started today will fail within the first 5 years. So that means everybody on the call, only one of y'all gets to succeed after 5 years. Everybody else is going to fail. Like if I took the number of people on the call, right? That's it. Oh my gosh, really? That's horrible. Like, why not just go back to corporate America? I mean, those are horrible odds, aren't they? Except I have hope for you, because they have done this. Dun & Bradstreet did a research and did a study that found that entrepreneurs who avail themselves of a business coach, and they specifically name the SBDC, so such as the SBDC, increase their odds of being in business in 5 years from the 10 to 25% to 90%. So like instead of just one of you being in business in 5 years, 90% of you can be in business in 5 years. That's how much you increase your odds. It's so amazing. And did I say it's free? Oh yeah, it's free. It's a good deal. Now, the other thing is that I want you to know, there's a book that I highly recommend getting. And if somebody can type it out in the chat for me, that would be fantastic. Because from what I understand from most people, they can't see when I write on this backboard, even though we've tried multiple times to get it right. It's just too far away, I guess. So it's the E-Myth, so it's E-MYTH, Revisited, by Michael Gerber, like the Gerber baby food kind of thing. And so I highly recommend getting that book, the E-Myth Revisited. What it does is it helps you to understand what hats you're going to be wearing as an entrepreneur and how to systemize your business. Because if you systemize your business, you increase the value of your business. Because if everything is in your head, and right, like there's so many businesses, like I actually inherited, long before I started my chocolate business, I actually inherited another chocolate business, go figure. Only I couldn't actually run the chocolate business because literally the recipes were in the guy's head and he died. His system for taking orders were Post-it notes on a bulletin board with the customer's name and number, and he just remembered what the order was. Genius, I guess, because he obviously had a really good memory. And so there wasn't a business that was systemized that I could just walk in as a total stranger and run it. But think about that. If you want to sell your business eventually, which is a good deal because, you make money on it, right? Hopefully. If you have it systemized, you increase the value because anybody can walk in off the street and be able to run the business because it's basically runs itself. It also allows you to be what I highly recommend being, which is the second type of business owner, because we have two types of business owners. We have a business owner that creates a job for himself or herself. Sorry, I got hot here. Here. So they create a job for himself or herself, and that's it. They work in the business, not on the business. They're an employee of their own business, right? And they work 16 to 20-hour days to make it successful. And those are the ones that tell me, oh, I can't go on vacation because I lose money when I do. No, you want to go on vacation. Life is about experiencing things. I'm going to get hold on. Well, shoot. There we go. Cough drop. Sorry. I have gum in my mouth, which should help, but when I get hot, I start to cough, so that doesn't help. Anyway, I apologize. Okay, so the second type of business owner is the one that the E-Myth Revisited helps you to become. Lots of coaching programs help you to become. Specifically, Strategic Coach is a good one for that because they help you to understand how to have a self-run business. In other words, the business runs better when you're gone because it's systemized. And so that is the type of business owner you want to be. It's a business owner who has time to work on the business. They sit and think about, who are my 10 biggest clients that earn the most money for me, and how can I repeat that? How can I grow the business? Should I sell widgets or should I sell gadgets? How can I improve the processes of the business? Those are owners that are working on the business, not in the business. Owners that work in the business don't have time to work on the business because they're too busy serving their customers or their clients or managing employees and things, rather than determining what direction is the business going, steering it, right? The owners that work on the business are the ones that increase the value of their business. They're the ones that can step away from the business and go on a trip to Fiji for 6 weeks and come back and the business is still there and running and they haven't lost any money. And they're the ones that go home and see their family at the end of the day instead of working 16 to 20-hour days. How many of y'all want to be owners that work on the business? Yep. That's a lot of what the SBDC can help you with. That's what that book can help you with. And there's lots of coaching programs. But like I said, the SBDC can help you because it's not what you, or it's what you don't know that hurts you in business, and you don't know what you don't know. So we need to find a way to understand how to know what we don't know. Okay. All right. So the first thing that, oh, hold on. There's a lot of things. Thank you so much for typing that in. I appreciate it. Oh, white paper. A white paper is a research paper, usually done at a university or something. They charge a lot of money for them. So if you wanted to buy, like associations will do them sometimes to research the state of the industry. And it is, the white paper that I had was like 40 or 50 pages long, telling me here's the growth over the trends of this particular industry over a period of time. Here's how it will continue to, we think it's going to continue to do this, et cetera, and here's why. And it's a lot of research. If I had wanted to pay for that white paper instead of being able to get it through the SBDC for free, it would have probably cost me about $2,000 or $3,000. They're not cheap because they got to pay for their research, but they make it available to the SBDC for free. So that's always nice. Okay. So the first thing I cover on this class is myths about lawyers. And the first one, and the reason why I do this is because a lot of times people are encountering working with a lawyer in a partner position for the first time. They may have dealt with lawyers before, like maybe they got a ticket and so they wanted to get out of the ticket, so they hired a lawyer, or they got a DUI or a minor in possession when they were in college, so they had to hire a lawyer to get them out of that. Or they've been divorced and they had to hire a divorce attorney. And so usually they are dealing with attorneys who are adversarial. They have somebody on their side, but they're also fighting another lawyer on the other side. And it can be very adversarial. This is usually why people say, oh, I hate lawyers and things like that. But I mean, business lawyers, corporate attorneys should be similar to a partner in your business. They're there to help you succeed. They're there to help you build your business. There's no adversarial about it. And in fact, a lot of people think that business lawyers are cost centers. Like a lawyer just costs them money, right? But a good business lawyer is actually going to save you money. And that's what you want. You want a lawyer who is there to help you save money. I had a client just the other day come up to me and say, you saved me $25,000. And I didn't know what I had done to do that, but I had actually negotiated something into her lease that allowed a cap on repairs of her AC unit for the space that she was renting. She was renting a 1,500 square foot space. It wasn't that big, but the AC unit went out, and because it was on the roof and had to be replaced and it had to be a certain size and all of these requirements, it was a $25,000 replacement, and I had capped it at $500 for her. So the landlord got to pay that $25,000, not my client. So those are little things that we can do. You should actually work in partnership with your lawyer rather than thinking that they're a cost center, because a good business attorney will save you money. So that takes me to the first myth, which is a lawyer can work on any type of legal matter. I have people that call me up all the time wanting me to sue people or do a divorce or do an estate plan for them. And I don't do that stuff because that's not my expertise. I can refer them to other attorneys that are specialized in that, but law is so specialized now that you really want somebody who specializes in the exact thing that you need, so that you make sure that they've been there, done that, and have the t-shirt, that they have the experience necessary to look out for the traps for the unwary and things like that. And so that's really it. And I kind of liken it to medicine. It used to be in the small town, you'd go to the doctor and, he'd birth your babies. He'd, treat your kids as they're growing up. He'd, operate on you when you had a broken bone or, fix the broken bone or whatever it is. But that's not the case anymore. I mean, if you needed brain surgery, would you go to a heart surgeon? No. You'd go to a neurologist, particularly one who had done that type of brain surgery multiple times very successfully, right? That's what you would be doing. It's the same with the lawyer. You want to make sure that you find somebody who has the expertise that you need. If you are wanting to build a home, you need a construction attorney who will review that type of contract for you. If you need to do estate planning for your family, you need an estate planning attorney. So you really want that specialty. You don't want a jack of all trades, master of none, right? Now, the second myth that most people think of lawyers is we just fill in the blanks on a form and then we charge you an exorbitant sum for filling in the blanks on a form. I wish that were the case, because I could sit and eat bonbons all day and lay around the pool and not really have to work, but that's not the case. A good lawyer is going to personalize documents specifically for your business so that what it is that you need will satisfy and be something that will protect you. Even something as simple as a non-disclosure agreement or a confidentiality agreement. Those things are the same, but even something as simple as that, the confidentiality agreements will vary according to what your business does. Now, is there a language in the agreement that's similar in every single agreement? Oh, heck yes. Why? Because we've researched it before we drafted it originally, and we found that if we draft something this way, a court will accept it better, or they'll interpret it one way. But if we draft it a different way, the courts will interpret it another way. And so, we do that, but we also have to keep up with all the court cases coming down that might affect all the documents that we've drafted and everything, and all of what most people call legal boilerplate. It's not legal boilerplate, but it is stuff that we know works, right? And so, yes, so there will be similar language. But in a confidentiality agreement for a manufacturer, it's going to be totally different than one that I do for an employee who is preparing recipes for a bakery, so that they don't steal the signature cupcake of that bakery when they go off to the competitor. And so we really draft very, very different contracts depending upon the business that needs to be protected. So while I would love to say we fill in the blanks on a form, we don't. And I can tell you that the companies that do, like LegalZoom and Rocket Lawyer and all of those, I'm not dissing them. If you need to use those because that's all you can afford, I totally get it. But just know that they are filling in the blanks on the form, and they are not asking you all the questions that a lawyer would ask you to determine what's best for your business, how to form that entity, how to grow that entity, how to poise it for growth and everything. And so the litigators that I talk to say, yeah, LegalZoom and all of those, they keep me in business, because especially if they're business litigation lawyers, they are usually litigating disputes between partners and all that could have been avoided had they gone to a lawyer in the first place, rather than just taking the boilerplate that LegalZoom or Rocket Lawyer does. I got one of my clients had done, gone to them and gotten, and I don't remember which one it was, but they had an 8-page operating agreement that required that they perform an audit, a financial audit of their company on an annual basis. She had other owners in her business who could have sued her for not doing that, because in the agreement it required it. That is very expensive for a small business. They're about $10,000 to $15,000 to do an annual audit, and there's really no reason to do them for a small business. Unaudited financials can work to send out to your partners. So I was shocked that that was in there. We got it out really quickly. So I just was like, wow, that wasn't thought through very well. Yes, I am a business lawyer. Somebody asked if I was a business lawyer. What I do is I work with entrepreneurs and I help them start and grow their businesses. So like some of my clients have started with me, they start out really small and they've grown to multiple millions. And then I have some clients that are like, you know what, I just want to stay small. And so it's just them. They decided not to manage any employees and all. And so they stayed small. Or like $100,000, $200,000, $500,000 a year or so. And that's totally fine, because that's what they prefer and they know. So I do teach another class at the SBDC. It will be offered, I think it's December 2nd, if that's a Wednesday, at this time. It's 6:30 to 8:30. It's not as long. I'm not as wordy for that one. Anyway, and so, but it's on employees versus independent contractors. And it's really like this class I teach on a monthly basis. And this is geared towards people who are starting their business. But if you're in growth mode, meaning, okay, I'm tired of working 16 to 20-hour days, I need to hire somebody else so that I don't have to do all the work. Well, then that's when you need this class, because it's going to talk to you about whether you should hire an independent contractor or an employee and how to tell which one you need to do. And it's then going to tell you a lot of employment laws and independent contractor laws that you need to be aware of as a small business. So I teach that class 4 times a year, typically quarterly, but 2020 has been odd, so not quarterly this time. So, okay, so how do you choose an attorney? Well, the first thing you need to do is go to texasbar.com. And on that site, you can do an attorney search, and you can do an advanced search there. So it has all the attorneys that are registered or licensed to practice in the state of Texas listed there. And it's great because you can search like, oh, I only want a Harvard lawyer. So you can search for Harvard lawyers, or maybe you're looking for somebody who's certified in a certain area like estate planning or trial law. And so you can find that as well. But what it doesn't tell you is, are they any good, right? Do clients like them? So go to avo.com for that. It's kind of like an Angie's List for lawyers. And there you can search lawyers there for whatever topic you need. And then you can get a profile on them. Now, some attorneys haven't claimed their profile. They don't like Avo, whatever. So you may not get as much information on them, but there are a lot of attorneys that have claimed their profile and they have reviews. So their clients can give them reviews. Their colleagues or other attorneys can endorse them. And so you can really see that. But I also love it, even if there's no reviews or anything. What I love Avo for is if the attorney has claimed it, they will have listed what their area of practice is. And there's like a pie chart. And it will tell you whether they're a jack of all trades, master of none, or if they're a specialist in their area. So for example, if you see business litigation, personal injury litigation or personal injury, entity formation, estate planning and probate, and criminal defense. That's a jack of all trades, master of none. They're too disparate of the practices, like that's just way too disparate. However, if you see instead entity formation, business acquisitions, real estate, intellectual property, contract negotiations, that's all related. That's all business related, and you can tell that they're a business specialist at that point, and that's what they do. Okay, so you want to look for that. Like I was looking for a construction attorney, and I had looked on texasbar.com. I needed to refer one of my clients, so I'd looked at texasbar.com, and I'd found somebody who said they did construction law, and it looked like it was their only thing. But then when I went on Avo, it was like construction law, personal injury, estate planning. And I was like, oop, never mind. And they only did construction law 10% of the time. So eventually I found 2 attorneys that I refer to for construction law, that's all they do 100% of the time is construction law. It's important for that because there are traps for the unwary with the various construction contracts that you do, whether you're building your own building for your business, or whether you're building a house. You need to have a construction lawyer review all of that so that you don't get into traps for the unwary. So that's why I found those, because my clients were doing that. The last way to choose an attorney is friends or colleagues referrals. You know, if you know somebody who's an entrepreneur, ask them, who do you use? And then ask them, do you like them? Are they good? Because that will make all the difference in the world, okay? So definitely depend upon your friends to give you referrals. That always helps as well. Okay, so I like lawyer jokes, so feel free to, tell me lawyer jokes at the end. So what do you look for in an attorney? Well, the first is integrity. And I'm not meaning that they have to have a halo over their head. What I'm meaning is they need to match your integrity level. because there's 3 people that are going to be key to the success of your business. The first one is your banker. Your banker is going to help you to monitor and manage your cash flow. And they're also going to help you with, I gotta close this door. They're vacuuming just outside here. So I'm sure that was a lovely sound. Apologize for that. Anyway, so your banker is going to help you with your cash flow, and cash flow is king in a business. It makes a huge difference. If you don't have cash flow, you don't have a business. For example, you get in an order for baby clothes. You're producing baby clothes, you're a designer. And so you get this order in, and it's for $100,000 worth of baby clothes. Great, that comes in January. You have to then go buy the material and the buttons and the zippers and the snaps and everything for the baby clothes and the ribbons. And that's like, say, end of January, you do that. So you have to pay for that, $30,000 and then, or $20,000. And then you have to pay for the labor to manufacture the baby clothes. That's going to come in February when they're manufacturing those, right? So that's another $30,000 or whatever. So now you've spent $50,000. Then you've got to ship it to Nordstrom, who bought the clothes, right? So that's about $5,000 in, say, March. Have you gotten paid yet? Nope, but you've had an outlay of about $55,000, but you're going to make $100,000, right? So when do you do that? Well, once everything's delivered to them. So let's say it takes 2 or 3 weeks to get there because your manufacturing is over in China or wherever it is. And so it goes on a slow boat, like to ship, and it takes a couple weeks to get there. So it finally gets there beginning of April. And then you give them the invoice, because that's when you get to invoice them. And not every business works this way. Some of them you pay before delivery, but this is the way the clothing industry works. So you invoice them, and your terms are typically 45 days out. So if you're lucky, they'll pay on time, and you'll get paid in mid-May. When the order came in and you started expending money for this order in January, right? That's cash flow. If you don't have the money to manufacture, to pay for the materials, to pay for the labor, to pay for all of your other expenses, to keep the lights on, to pay for the rent, until that money comes in, you're going out of business. That's what cash flow is. So your banker can help you with cash flow. They will also help you with your credit score, because when you're starting your business, your personal credit score is your credit score for your business, and you need to build that up. So your banker can help you with that. And the way they do that is through doing like a revolving line of credit, which is always good to have in case emergencies happen or whatever. And so you would get that, you draw down on it occasionally, and then pay it off over time. That gives you credit. That gives you good business credit by doing that. It's also good as soon as you're able to get a revolving line of credit to get one. I recommend it. Some don't want to deal with that. They self-fund, but as long as you have a backup plan and you have a certain amount of savings or a loan that you can get in case something happens in your business, like, oh, I don't know, COVID, or like in 2016 in May, it rained 26 days out of 31. It put a lot of mom and pop shops out of business because they hadn't planned on something like that. May is typically for seasonal businesses like gardening, pools, that type of stuff. That's their biggest year or month of the year for earning money. And if it's raining, are you out gardening? Nope. Are you out doing home repair? Nope. You're not doing any of that. And it's not like once it becomes sunny again in June, you go, wow, okay, now that it is, I think I'll go ahead and plant all of those things that I normally plant in May. Instead, you go, yeah, too late this year. I'm not going to do it. So then they have spoilage, so that they've already bought the product. They've spoiled the product. So they've lost money that way. And they didn't have the money coming in from the sale of the product. And so I saw a lot of GoFundMe's at that time from mom and pop shops saying, hey, we're your local hardware store. And this month was really hard on us because it was raining so much. Something as easy as Mother Nature took down businesses simply because they didn't have it planned. But if they'd had a revolving line of credit, they could have drawn down on it and then paid it back over time as they've slowly recovered from it, right? Now, give you a little tip here. Banks don't loan money to people who need money. They loan money to people who don't need money. So if you are thinking, oh, well, I'll just go get a loan if that ever happens, well, they're going to look at your financials and see them tanking, right? They're not going to loan you money. That's why that revolving line of credit, to be able to draw down on it when you need to, is a big thing. That's a good thing for you. Okay, back to the integrity. I kind of went off on a tangent, but back to integrity. So the second person who's crucial to your business and is similar to like a partner is your CPA. The person that does your taxes, because they are going to help you to minimize your tax liability. And they're also going to help you to grow your, manage your tax flow, or cash flow. They're going to help you manage your cash flow. So that's also important. So you've got two people, your banker and your CPA, that'll help you with that cash flow. They'll help you to understand that. They'll help you to understand your financials. Where are you profitable? Where are you not profitable? That type of stuff. So when I'm saying integrity, matching that integrity for your CPA and your attorney are very important, because if you are extremely conservative and your CPA is like, oh, so hey, you should do this and this and this. Yeah, it's a little shady. Maybe the IRS may not like that or whatever, but you probably won't get caught. You're not going to get along with them at all, right? But if you are the type that is okay with a little bit of business risk and is like, give me every deduction I can have. Tell me how I can take a vacation on the company dime. That type of stuff, which you can do totally legally. You just have to do certain steps to do that. And your CPA is extremely conservative. You're not going to get along either, because you're like, tell me what deductibles or deductions I can have. Oh, well, let's look at your expenses, that type of stuff. And so it's going to be a fight with them all the time, and you're not going to want to use them as much. Same with your attorney. If your attorney is a risk taker or a business taker and you're not, or vice versa, then those are things that you need to understand so that you know whether you're going to like them. And a lot of times it's literally just working with them that enables you to know whether they have that integrity level. And if they don't be afraid to fire them and say, I need to find somebody who matches my personality a little better, or something like that, right? We had in my family business, I've been an entrepreneur forever. My dad started a business in 1973, and I've worked every aspect of that business. I still do, because you never get out of the family business. They just keep reeling you back in. Anyway, but we had a CPA who had worked for us for 20 years, and he retired. He had the audacity to retire. And so we, he sold it to his partners, and his partners brought in some other people, and that we were there meeting with them about, our taxes and what we needed to be doing, and kind of doing a consulting. And we were lamenting about the fact that we had about $100,000 come in on like December 27th. And we weren't prepared for that. We thought that was going to come in January, but the people paid it way early, like way earlier than they'd ever done before. And so it was like, crud, we're going to end up paying taxes on that because we didn't have the expenses to counter it like we thought we would. So, one of the newer CPAs in the firm took me aside out of the earshot of my mother and said, so you should probably just put that in on the books as if it came in January. Just so you know, that's tax fraud. Yeah, that's tax fraud. And I made sure I understood that that's really what he was wanting me to do. And he confirmed that it was. And his attitude was, well, your chances of getting caught are really slim. And he was right. But we weren't willing to do tax fraud. We weren't willing to do any of that. And so, yeah, I went in and got my mom and explained what had happened and that we would be finding a new CPA. And it was a hardship on us, but that was our integrity level. We were not willing to work with a firm that would suggest that we commit serious tax fraud. Okay, so I have some questions. Are there agreements with a CPA or a lawyer? Yes, there are agreements with CPAs and lawyers. They typically will do an engagement letter that outlines your relationship, the fees, it's how you'll pay, talks about like attorney-client privilege, that type of stuff. So yes, and then they'll also send you a termination of the relationship letter. Now, if you're working with an attorney, I'm so sorry here. This thing worked for a little bit. Okay, there we go. I think she's gone, so I can open the door and get airflow again. Okay, yeah. So sorry. Okay, so yes, you will have that, and they'll terminate your relationship, like if it's for a project that you're working on for them. And the reason why we do that is our malpractice insurance requires it. So don't, like when you get, like when they send you a bill and then say, okay, our relationship is done, don't be like, well, that's rude. What did I do? It's really just because they have to do that too, because you have to make very clear who your client is and avoid any conflicts of interest and things like that for our ethics. So, okay. Would you please repeat that? I think I did. If I didn't, ask me afterwards. Okay. Now, what else to look for in an attorney? Experience in the area is huge. There are baby attorneys. This kind of goes with the price range as well, because the more experience an attorney has, the more they will charge per hour because they gained so much experience. You're paying for that experience and you're paying for all this knowledge that's in our head. Don't be penny wise and pound foolish, okay? Because a younger attorney that's maybe fresh out of law school, 1 to 5 years or something like that, we call them baby attorneys. I mentor a lot of baby attorneys. I had to start out as a baby attorney. I'm not knocking baby attorneys. What I'm saying though is, as an entrepreneur who's watching every nickel and dime, get somebody who's more experienced, even if they are higher in price range, and at least get somebody who's 10 or more years experienced. The reason is you don't want to have to pay for them to learn on your dime. Okay, that's it. You don't want to have to pay for that. And so here's the difference. Like, yes, you could get a baby attorney for $150 to $200 an hour, or you could get a 10, 15, 20-year attorney for $350 or so an hour, right? And here's the difference. When you call up an inexperienced attorney, they're going to say, oh, and you ask them a question like, can I fire Joe? And they're going to say, I don't know. Let me research that and I will get back with you, right? And then they're going to go do a couple of hours of research and you're going to end up spending $500 to $600 for them to learn whether you can fire Joe in that instance. But an experienced attorney who has been a business attorney for a long time is going to be able to typically say, can you fire Joe? Well, okay, let me ask this. and we'll start asking you questions to poke holes in it and figure out everything. And then we'll say, okay, here's how you fire Joe. And this is what the repercussions will be. And it's probably a 20-minute, possibly a 30-minute conversation for something like that. And at $350 an hour, do you see where your savings are? We just saved you money by you going to somebody with experience in the area instead of looking at the hourly rate, right? Because you're going to pay for the other person to learn, right? The secret here is they don't teach us how to practice law in law school. They teach us how to think like a lawyer. Once you get out of law school, that's when you start learning how to practice law. So that's why it's the experience in the area is so important. Now, common business sense is not required, but I highly recommend it, because if they don't understand your business, if they don't understand how to read a profit and loss statement and understand that and a cash flow statement and a balance sheet actually have two numbers that interrelate, if they don't even know how to read all of those, they don't understand pro formas, they don't all of that, they don't have that common business sense, they're not going to be able to adequately represent you. You're going to get frustrated with them because they're not going to know your business well enough to adequately represent you. So that's just something, obviously, when you start working with them, you'll know whether they have common business sense or not, because they'll be able to relate to your business and they'll be able to talk to you on your level about your business. Right? Like they may not be able to talk about, like if you're a technology company, they may not be able to talk about like how to code, but they understand coding and the implications of that and how it's virtually impossible to code something without using plugins nowadays, right? If somebody wants for you to code for them and not use plugins, that's going to cost them $500,000 or $1 million instead of the $20,000 they want to pay you, right? So, there's licensing stuff rather than transfer of ownership at that point. If they don't understand that type of stuff, they're not going to be able to adequately represent you. So they really need to understand your business. One of my clients manufactures the interior of airplanes. Custom airplanes. So he does like the cabinetry and all the pretty seating and everything for it, for custom airplanes. And he needed me to draft an agreement for him. And so he was talking about phenolic panels and other things like that. And I was like, don't even understand those yet. Let me come learn your industry. And so I went down and got a tour of his place, which was great because I needed to understand, how does an order come in? How does the engineer tell you how to build things? What happens if it doesn't fit? Like, it's an inch too big or something like that. It doesn't fit within the airplane. How do you determine whose fault is it? Who has to pay to have it redone? That type of stuff. Because if I didn't understand the process of how that airplane was built and where they fit into that full process, I couldn't have drafted the agreement for him to protect him. It just wouldn't have worked. So very important. He was like, I don't want to pay for you to learn my industry. I'm like, oh my God, this is going to be so much fun. I love learning new stuff. So I went down, no charge. And your attorney shouldn't charge you for something like when they're learning about your business. That's really to help you, right? And so they shouldn't charge you for that. That's just my personal opinion. I'm sure some attorneys do charge, but I don't know. Okay, working with your attorney. I spent a lot of time on this because most people haven't yet worked with an attorney in a business setting. So the first thing is be open and honest. You are going to have embarrassing conversations with your attorney. It's okay. I've had conversations about, we've got to fire so-and-so because they've been watching porn for 4 hours a day or 6 hours a day while they're at work. That wasn't the embarrassing part. It was that it took them 4 months to figure out they weren't getting any productivity out of this person because they'd been watching porn all day in their office. And they were like, how did it take so long for us to figure that out? You have something called attorney-client privilege with your attorney. What that means is even a judge cannot compel us to disclose what it is that we have discussed with you. He cannot get to the emails. He cannot get to texts. He can't get to any of that. He can't say, well, what did you tell him? Well, what did she tell you? None of that. It's attorney-client privilege, and it is a very sacred privilege. However, you can destroy that privilege. And the way that it's usually done is your attorney sends you an email. And it says something like, okay, so I've reviewed the contract and here are the points that I find problematic. Here's how I think we ought to negotiate this. And you go forward and you forward it on to the other side. No, 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 no. Never, ever, 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 ever. Repeat after me. I will not forward an email that my attorney has sent to me. Because as soon as you send that email to a third party who does not work for your company, you destroy the attorney-client privilege with regard to that subject matter. So make sure that you guard that attorney-client privilege and treat it as sacred as it is. Now, like I said, you're going to have embarrassing conversations with your attorney. The most embarrassing conversation that most people have is your attorney has said you need to do A. If you don't do A, X is going to happen. And because you're an entrepreneur, you're really busy in your business and you don't do A because you're so busy, and X happens. And then you have to call us and you have to say, I didn't do A and X happened. Now what? And I swear, like, clients think we're going to go, I told you so, I told you so. Yes, yes, yes. Woo, I was right. No, that's not what we're going to do. What we're going to be like is, okay, so tell me what's happening with X, and then we'll figure out how to get you out of that. And then once we get you out of X, we're going to say, okay, you want me to go over A again? And you're going to say, oh, yeah, go over that. Absolutely. Let's go over it. I promise I'll always do A. And about 6 or 7 months later, you're going to call us up again and say, I was too busy to do A. And X happened again, and we'll help you through it. You know, hopefully you learned your lesson and you do A all the time, but you know, sometimes you just get too busy and it's okay. And we're going to get you out of that because that's our job. And we're not here to judge you on how you're running your business. We're here to help you run it better and keep you out of trouble. So now, other ways to work with your attorney. The first is state your expectations. That goes with asking for an estimate of cost and calling in advance of needing something. Because while we would love for you to think that you are our only client, we are typically juggling 5 to 10 clients a week with various matters, unless we're doing an acquisition and then we're only working on that one and we don't have time to do anything for anybody else at that point because we're working on an acquisition, which takes up a lot of time. So you want to call as soon as you can, as soon as you know something's going up. Now, does that mean that you can't call with an emergency? No, absolutely not. You can call with an emergency because we get it and our clients get it. And they say, oh yeah, okay, I get that you needed to have time to review this and you're busy. So, like my clients, if I say, oh, I'm sorry, an emergency came in, I had to drop everything. I know I said I would get this to you today, but it's going to be tomorrow because I had to drop everything and work on this. And they're like, sure, because they know I would do that for them too if something emergency happened. So it's okay. But if you're the type that always has a fire drill, you're always calling at the last minute, then yeah, you probably ought to rethink that, right? Because we need the advance time. We need to be able to fit it in, like, okay, here's my work schedule. Okay, I can fit it in and do it on this day, I think. I might actually go over to the next day though and let you know. I think I can get it done here, right? So that's why calling in advance of needing something and asking for the estimate of the cost and all, because you may look at a lease agreement and go, oh, well, I reviewed that in 30 minutes to an hour. Probably ought to take you about an hour to review it. Well, except that lease agreements are about 60 pages long in 6-point font. And You didn't read that agreement in an hour. You scanned it. You didn't read every word. But corporate attorneys or business attorneys have to read every word of an agreement because every word can make a difference in the agreement. So we will go through that entire 60-page document, read it, and here's our job. We look at an agreement that we're reviewing for you or drafting for you, and we determine what's missing that will benefit my client. What is in there that's bad for my client that I need to change the wording of to make it better for my client? And what is in there that I don't like that is bad for the client, but I have to leave it in because I know that's what market standard is. Like there's no way the landlord is going to agree to no late filing or no late payment fees, right? They're gonna require late payment fees. So I can't get that out of there, but I can try and negotiate it down, that type of stuff. So in reality, a thorough lease review is usually 6 to 7 hours. That's a major expense for a small business. But here's the deal. Your two largest expenses in your business are your employees, your payroll cost, and the second largest expense is your real estate or rent cost. So it's worth it to have that attorney review it to try and negotiate for it better so that it is more advantageous for you and you're not caught unawares, right? So definitely ask for an estimate of the cost, because if you're expecting an hour-long review and they come back with a 5-hour review, you're going to be a little pissed at your attorney, right? That's where that state your expectations. If you need it in a week, let us know. If you need it in a month, let us know that so that we can get that drafted for you, okay? That's that call in advance of needing something. I had a client call me on a Sunday afternoon. There were two problems with that. He called me on a Sunday afternoon and I answered. And I answered because I thought it was one of my clients that was calling because I was working that weekend on things for this particular client because I had 3 acquisitions going on that were closing that week. It was like 2 of them had been delayed and delayed and delayed. And finally we're like, yeah, we're closing. So all of a sudden I was like working overtime, big time, to get everything closed on time. So this other client calls me up on a Sunday and wants me to draft an employment agreement. My first question was, when did you start interviewing for that position? Oh, about 4 weeks ago. Yeah, 5 weeks ago would have been when you needed to call me, because I could have saved him money at that point because he really didn't need to hire them as an employee. He could have done an independent contractor and that would have saved him money. And if you're wondering why that is, go to my other class. Anyway, but so I could have saved him money, but instead he called me that Sunday and the employee was starting on that Monday right after. I couldn't have helped him if I wanted to. I was so busy with these acquisitions. It wasn't fair of me to say, oh, well, you know, I'm sorry, I can't do your $5 million acquisition because this guy needs an employment agreement that he should have called me about 5 weeks ago, right? That's not fair to that client. That's not an emergency. That's just lack of preparation. So if it had been an emergency, I would have figured it out how I could fit it in, or I would have gotten another colleague to do it for him. So instead, I could only send him to a colleague and say, he may not answer the phone on a Sunday, which of course they didn't because they were taking Sunday off to be with their family. So that's a big thing. The other thing is call before you take an action, such as firing an employee or terminating a contract. Those types of actions are where we can save you money, because you may read and say, oh, I can terminate this contract. It just says 30 days notice. Or, oh, I can terminate this contract. See, it says if they breach, I can terminate immediately. Except you didn't do the read further rule. And on another page, it required notice and opportunity to cure. Or it was a different situation that actually applied in your situation and required 30 days advance notice. I had a client that they terminated somebody. It was an independent contractor agreement. They had an like a executive helper, administrator, and they terminated her one morning. And without notice, just immediate termination. Well, the EA sent this client a bill for $4,500, which is what her fee was for the month. And they said, we're not paying this. You didn't do anything for us. We terminated you immediately, except that the agreement required a 30-day notice. And so because they didn't provide the 30-day notice, she billed them for the 30 days, right? And she sued them for it. So they ended up having to pay it. So they wasted $4,500. And when she came back and said, no, you should give us 30 days, or you had to give me 30 days notice, right? They said, oh, well, you can continue to work for us for 30 days. Do you think she was going to do that? No, obviously not. She had a sour taste in her mouth from all of that. So no, she wasn't going to do that. So they spent $4,500 and got nothing for it. When if they had just contacted me, it would have been a 10-15-minute conversation about how to properly terminate that contract and how to do it in a way that the EA was like, oh, absolutely. I totally understand. I will set you up and get you good for this next 30 days. Absolutely. I will do everything that you need to so that you can get in a better position. We would have done it so that they would have actually gotten work out of her and not wasted that $4,500. It's the same with firing an employee. If you do it wrong, you can have a lot of liability. Now, the final thing is let your attorney draft the contracts. I am not saying this because I think that attorneys need more work. I am saying that because it will save you money in the long run, a lot of money in the long run. For example, one of my clients, and this is the issue, is that it's so easy to get documents off the internet, right? Like you can go and search confidentiality agreement and pull down hundreds of them, right? Except that the problem is that you don't know who drafted it. You don't know if they were an attorney or not. You don't know if they got an A in their class or a D, right? Because D means diploma. You don't know if they were in the top of their class or the bottom of their class, and you don't know their experience level. But worse, you don't know the reason that that agreement was drafted. You don't know what the use of it was for other than the title, right? So one of my clients, they pulled down a confidentiality agreement off the internet. And luckily his wife said, have you run that by Terry? He's like, it was hilarious because he calls me up and you can tell he's frustrated with his wife for even making him call me. And he's like, my wife says I need to have you review this. So do you have time? I'm like, yep, sure, send it over. So I reviewed it. It was the worst confidentiality agreement I had ever seen. Like I couldn't use any of it. I couldn't even just modify it. It was so bad. I just started over from scratch. It didn't adequately protect. But what was worse is it had a 3-year term in it, which meant in 3 years, whatever it was they were keeping confidential via that agreement. And so just so you understand, my client was going to a manufacturer to disclose his trade secrets to get products manufactured. So in 3 years, he would have lost the entire value of his business because the termination provision meant that the manufacturer could disclose all of those trade secrets to whoever the heck he wanted. And he could start manufacturing the products himself and selling them instead of my client. So here's my client developing a market for something, and the manufacturer that he's using could just undercut him once that market was developed. So entire value of his business, it was about $700 for me to redo his agreement, or actually I just started anew and drafted from scratch for him. Pretty sure going to the attorney was worth it. And he agreed. He was shocked to know just how bad what he had pulled off the internet was, right? So now why was it there? Because it was for a cell phone manufacturer, and your cell phone is obsolete within a year of it coming out. And so they don't care in 3 years what's disclosed. Okay, so let's go to choice of entity. In the handouts, there's a choice of entity chart for you. Feel free to look at that. I am not going to go over that because it's just really dry. But what you need to know is there are only two forms of businesses, entities, that protect you from liability, because that's the reason why you want to form an entity. That's the benefit. Protection from personal liability. Now, you can still have some, and we'll go over that in a little bit. It also shows that you're serious about your business. But the only two entities are a corporation and an LLC, or limited liability company. Now, on that handout, there's 4 columns for that, because there's a series LLC, an LLC, an S Corp, and a C Corp. That's because they can be taxed differently, and a series LLC is a little different than an LLC. If you want to learn about series LLCs, ask me afterwards. I don't go over them in here because most people don't use them. But the benefits here are serious about your business as well, and that. Now, what the rule is for personal liability protection is when you form an entity, the owner of the entity, meaning an LLC or a corporation, I'm not talking about a partnership or a sole proprietorship, I'm not talking about any of those. But when you form your LLC or corporation, the owners of that entity are not liable for the debts of that entity except to the extent that they put money into it. So what does that mean? Well, you form an LLC and you put in $100,000 into it to get the business up and running. Let's say it's a restaurant, okay? And late one night, your employees are cleaning up and they've mopped the floor, but there are still patrons there drinking. And one of them gets up to go to the bathroom. She's got these spike heels on. She slips, as often happens with the spike heels. She slips, falls, cracks her head open, and dies. I know, very morbid, but that's my job. I have to go with the worst case scenario. So her family sues your restaurant because they're like, wrongful death, right? Because like you should have put a warning there for her, etc. And so they find $5 million in liability. Your insurance will typically cover around $2 million. That's the typical policy for a restaurant. So it'll typically be $2 million. So that means there's $3 million of a judgment not satisfied. Who owes that? The LLC owes it, not the owners of the entity. But if they have put that $100,000 into the entity, they'll lose that because it's in the entity and they haven't gotten it back out, right? So that's you're not liable as an owner except to the extent that you put money into the business because it's in the business, right? So once it's in the business, that money can be used to pay for liabilities of the business. So what happens is basically the business declares bankruptcy and all the assets are sold off to pay for that judgment. That's really what happens. So then you go off and start another restaurant or start another business and learn from the first mistakes. Okay, so what are the disadvantages of an entity? Because you can forming an entity does have disadvantages. It's not all good and glorious. So the first is the Texas franchise or margin tax. Now, what is that? Well, in Texas, we used to have a franchise tax, but in 2007, it changed to the margin tax. But nobody's apparently told our comptroller because they still call it a franchise tax. So just know those are the same tax, right? Like when somebody says franchise tax, they're meaning margin tax, okay? Now, what is it? Well, in Texas, we have a state constitution that says it is unconstitutional to have a corporate income tax. So we just call it a margin tax or a franchise tax. Shh, don't tell anybody, right? Like, that's what it is. It's a corporate income tax. It's just that our legislators in their infinite wisdom have figured out how to manipulate the language of it and the process of it so they can technically call it not an income tax. Because basically what they do is if you have 1.2 million in gross revenue, say during 2020, by May 15th of 2021, you will owe approximately 1% of your net revenue. Now, it's not really an income tax because in order to come up with that 1% that you have to pay, you have to add back in your owner's salaries and stuff like that, or they can calculate it based on cost of goods sold, or there's 3 different ways to calculate it. Make sure your accountant does it. Don't bother with it yourself, okay? So it's kind of like an income tax, right? Now, some of y'all probably just turned off your ears and went, well, I'm not going to be making 1.2 million anytime soon, right? Yeah. Okay. Except that you are, right? Like you still have to deal with the franchise tax, even if you don't make 1.2 million, because every May 15th, as long as you have your business, you have to file a franchise tax report. And you go, yeah, but I didn't make the threshold. Well, you have to file what's called a certificate of no tax due. If you fail to file it timely or file an extension and then file it timely, then they will, the comptroller will assess a $50 penalty against you. And then if you continue to fail to pay it and file the franchise tax report, then they will revoke your entity. And then you got to go through this long rigmarole to get it reinstated. And pay all these penalties and everything. So it's easier to just put it on your calendar and make sure you file it. So here's how it goes. You say, put it on your Google Calendar or your iCal or whatever it is, and then make sure that it repeats every year. So like on May 1st, it says, hey, have you filed it? Have you filed your franchise tax? On May 5th, you got another one that pops up and says, no, really, have you filed it yet? Right? And then on the 10th, it says, you've only got a few days to file it. And then on the 14th, it says, file it by this day, or else it'll be too late. Because if you're filing electronically, you need to do it the day before because of the way that it all works. So you want to make sure you get it done. Okay. I love those calendars that have those reminders. I mean, I have things on my calendar for 2030 already. You'll see why later. Anyway, okay. What other disadvantages are there? Well, there's corporate formalities. And I'm going to get to those in a minute about what those corporate formalities are. There's also increased legal and accounting expenses because you now have to file a tax return for the entity instead of just filing your own personal tax return with like a Schedule C on it or a K-1 if it's a partnership. So now, if you have an LLC and you're the only owner, you can actually file a return with your personal return. But if you have another owner, I highly recommend filing an individual LLC return. Because if Joe and Sally have a business together, and let's say at the end of the year, Joe owes $100,000 and Sally owes $100,000, right? And Sally doesn't pay it, and y'all haven't filed an LLC return, the IRS doesn't know what Sally owes, right? So Joe is actually liable for Sally not paying those taxes, and the IRS can come after Joe for her $100,000. However, if you file an LLC tax return that says, hey, IRS, Joe owes this and Sally owes this, that cuts off Joe's liability for what Sally didn't pay because the IRS knows that Sally owes that. So that's why you want to always file those returns, especially if you have business partners. Now, where to form, Texas, Delaware, or Nevada? Texas. I'm a Texas gal. I like Texas. But the only time I file in Delaware, and it's really losing its appeal. I rarely form in Delaware now. And the reason is because most people are like, no, just file where, they know Texas is very pro-business, so they're fine with Texas. People used to file in Delaware because it was litigated out the wazoo, and you knew if there was a shareholder dispute, how it would turn out. And so the only time I ever file in Delaware is if I'm dealing with sophisticated investors from multiple states. But if it's just you or you and a partner or whatever, and maybe you're going to seek investors, maybe not, Texas works. Now, the only other reason why you would be wanting to be a Delaware entity is if you're going to go public, at which time we can form a Delaware entity and then merge the Texas entity up into it, and everything will be fine. Or we can convert the Texas entity to a Delaware entity, and it's fine at that point too. So really, Texas works, and it saves you money to form in Texas. It's not as expensive because your business is here in Texas. If we were to form in Delaware or Nevada, because your business is located here, it's a nexus that you have in Texas, right? Country song coming up. Anyway, so when you do that, you have to then file to do business as a foreign entity in Texas. And instead of just paying an entity formation fee of $308.10 to form your LLC in Texas, you are now paying whatever Delaware or Nevada charges, which they're much more expensive. Every filing that they do are. And now Texas requires a $750 filing fee to register as a foreign entity here in Texas. Just form in Texas. It's easier and cheaper. Oh, shoot, get the wrong way. There we go. Okay, so I am going to get to the formalities in a little bit. Just a second. I'm going to, only for franchise or for any LLC filed in Texas, is it only for franchise? What do you mean? It's the franchise tax? I think you mean, is the franchise tax only for franchises? No, it's for any entity that is formed or operates in Texas. Okay, so yeah, okay, got it. And what if it's husband and wife? Husband and wife, it affects how it's taxed, which I'll explain in a second. Okay, but it doesn't affect forming a business, right? Okay, so I typically only file limited liability companies now. The reason is because they're flexible. It's a beast of contract, and it's very flexible in how it's taxed. It's called a check the box entity, and you say, hey, IRS, I formed an LLC, tax me as a sole proprietorship, a partnership, an S Corp or a C Corp, and you can work your way up. So like my clients, when they're building their business and they know they're going to have losses, they are taxed typically as a sole proprietorship or a partnership. And then at some point, their CPA, and most CPAs tell me when it's around $50,000 per partner, in net revenue. When you attain that level, sometimes it can be more, sometimes it can be less. That's why I'm like, talk to your CPA, because taxes are a CPA thing. At any rate, but at some point, you get to the point where your company is doing so well that it's actually more tax advantageous to be taxed as an S Corp or a C Corp. And at that time, that's when you will, at the beginning of the year, you have a window of time where you can say, hey, IRS, tax me as an S Corp now. And you file a form 2553 and they go, cool, because they get their money faster. Because in a sole proprietorship or partnership, every quarter you're paying quarterly estimated taxes. In an S Corp, every time you get paid, they get paid within days of getting paid. Right? So they like it because they get their money more often. Okay, same with the C Corp. Now, the tip that I can give you, especially if you are like, okay, I can't afford a lawyer right now, or I can't afford the whatever, or I'm going to do it through LegalZoom. That's fine. Some people, that's what they want to do, or I'm going to do it through Rocket Lawyer. Just know that there is a question that they have that says something like, are you, as the owner, going to manage your business? And if you answer yes, the owners are going to manage the business. That throws you out of what is the default for LLCs. The default is manager managed, and it puts you as member managed. And that can be okay for your business, but if you're seeking investors, it's not. Because What that means is you won't ever be able to have a silent investor because your members manage the business. So instead, even though you're the owner and you're going to be the one to manage the business, you say, no, I'm going to have managers manage the business. And then you're going to appoint yourself as the manager. Get it? So always do manager managed, not member managed. Now, corporations, they're not as flexible. It's done by statute. And you can only have two types of taxation, S Corp or C Corp. That's it. No more flexibility. That's it. So when my clients that have LLCs go, hey, can we do this? I'm like, yeah, we can agree to that as long as it's not illegal. But with a corporation, they ask, can I do this? And I say, well, let's go look at the statute and see if the statute, in other words, the politicians who created the statute say it's okay for you to do it. So that's why LLCs are preferred. For example, one of my restaurant clients, when we were raising money for him to open a new restaurant, he was raising a couple $1 million and he was giving out, we'll go with 30% of the business, right? 30% of the ownership of the business he was giving to the investors in exchange for money. Now that is a transaction that's subject to securities laws. So anytime you are having an investor in your business, you need to work with an attorney, okay? Because you don't want to run afoul of securities laws. So anyway, so we're doing security law stuff here, and he's wanting to raise that. But he wanted to incentivize the investors to come in and do this money for him. And so the deal that he struck with the investors was he was going to give them a preferred return. So the ownership was 70% for the people that were putting in sweat equity, him and his business partner, 30% for the investors. And the deal he struck was, until you earn 100% of your money back, we will do a distribution split of 60% to you, 40% to the owners that own more, right? Like, so it was a 60-40 split where the investors were getting paid back at twice the rate that they would if they were just getting paid back for their percentage interest. This appealed to the investors. Now, as soon as the equity raise was over and they got their money back through distributions, right? Then it went back to the 70-30 split and they only earned 30% for their investment. But they'd already gotten their investment back and they got it back twice as fast as they thought they would originally. So they were thrilled to do that. We can do that with a limited liability company. You can do that with a well, actually, you really can't do that with a corporation. You have to do what's called a preferred return. It takes you out of being able to do an S Corp, puts you in C Corp status, right? Instead of other ways. And you have to file with the Secretary of State to tell them, hey, we have preferred stock now, and here's the terms of the preferred stock. Well, my client had really private investors that didn't want anybody to know what they were getting, right? So that's public information, but it's not in the LLC. It's done by contract, so it's private. So that's why the LLC is so much more beneficial. It's much more flexible, and I use it a lot more. Okay. This is just terminology of the differences. I'm not going to really go over that. So let's talk personal liability, because some people say, oh, I formed an entity, I'm not personally liable anymore. But remember, I said you may have some personal liability. Well, that's with officers and directors. We call it D&O liability. I should actually change that around so that's D&O, director and officer, but oh well. The first way is through gross negligence and willful misconduct. That provides you with liability in your role as an officer or director. And see, as owners, we're not just going to own the business, right? Like, we're entrepreneurs. We're working in the business. We're growing it. We're developing it. And so that's where that liability comes in, that's personal liability. So what is it? Okay, so gross negligence. You own a daycare. And in the summertime, you have a bus that goes around to all the little schools to pick them up at like mommy's day out and all that, and at the churches. And then they bring them to the daycare after they've done their little school or preschool or whatever it is. And you don't have a second person that when that bus arrives and the bus driver gets off, gets on that bus and goes, everybody out. Everybody up. Johnny, you fell asleep on the back seat again. Come on, go. Man, you've been tired lately. And you get the kid, right? And instead, that kid dies of heat stroke. It happens every year in Texas, right? It's awful. That's gross negligence. That's how they end up giving the director sole liability for that. Or the officer that made that decision, and you will end up having personal liability for the wrongful death action for that child. So that's gross negligence. The other one is willful misconduct. So what's that? Well, you own a bar, and as happens a lot, the bartender didn't show up, and so you've got to work that night as the bartender because business goes on whether the bartender doesn't show up or not, right? So you're doing the bartending, and some guy comes in and he's obviously intoxicated. He sits down at the bar and he says, give me a whatever, Moscow, no, I don't even know men's drinks, whatever, bourbon. Give me a bourbon and Coke. And you refuse to serve him because he's already intoxicated, right? And you could be found liable if you served him as he's already intoxicated according to TABC rules. So you actually are able to take his keys away from him as well to ensure that he doesn't drive, because he's like, I'm going to go off to this other place, they'll serve me. And you're like, no, you're not leaving here, right? We're going to get you sober. Here, have some water, right? And he's mouthing off and he says, your mama, blah, 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 right? And you go, whack, nobody talks about my mama like that. Oops. You're going to be liable for his broken jaw. You're going to be personally liable for that because that's willful misconduct. Okay. All right. Other ways that you can be personally liable are when you contractually agree to it. Personal guarantees. Whenever you get a loan or a line of credit, you're going to probably be required to guarantee the amount of the loan personally. That means if the business can't pay that loan back, you get to pay it back. And then there's also the commercial property lease, right? Okay. Whenever you do a lease, the landlord is going to require that you personally guarantee that lease. So if the business fails in 2 years and you've got a 5-year lease, you're going to personally end up paying the rest of the 3 years, or negotiating some sort of a settlement with them that allows you to not have to pay for the full 3 years. So it really just depends upon what you can negotiate at that time, but you're providing a personal guarantee that gets you on the hook. Now, I've had clients that have not had to provide that because of their track record, but when you're first starting out, you're going to be providing it. So, okay. Another form of personal liability is fraud. Fraud to the investors and fraud to the government. So the investors would be like, okay, say you've got an investor that wants to put in $1 million and you're like, yeah, you know, we have been negotiating this contract. Dairy Queen, they want us to produce this coconut cream icy type thing. It's going to be the answer to the vegan, I don't know, diet or something, right? So because they're going after the vegan market, and we've been negotiating with them and they are ready to buy. And so the guy goes, Dairy Queen, geez, yeah, heck, I'm investing $1 million. This is going to be great. $4,500 or 4,500 locations. You know, you're going to do great. And before he puts in the money, Dairy Queen calls up and says, you know, we found one we like better. So we've decided not to go with y'all. Oops. If you don't tell the investor that happened, then you are personally liable to that investor for whatever money that he loses, and he will sue. right? He'll eventually find out and he'll sue to get his money back, and you're going to be personally liable for that. So you don't want to do that. It's whatever would induce a reasonable person to invest in your business. If you fail to tell them that, if like whatever it was would either keep them from investing and you fail to tell them that, or you tell them something that's actually materially wrong, then that's fraud. Now, fraud from the government is a whole nother issue. So there's typically two types of fraud that I see in businesses. I do a lot of acquisitions, several a month. And usually what happens is they say, oh, well, here, this is what we make per month. And okay, great. And so then we start in the due diligence, and the CPA is reviewing it and everything and comes back and says, okay, so they said $100,000 a month net revenue on average, but I'm actually finding more like 85K a month or 80,000 a month or something like that. It's usually a lower number. So we go back to the seller and they do one of two things. They go, oh, well, come to the back room. And they show us the second set of books because they've been skimming off the top. It's usually in a more cash dependent type of business rather than a credit dependent type of business. But there are ways you can skim off the top through credit as well. And so that's fraud. And then the other way that they do it is they'll look and they'll go, oh, okay, let me show you the books. Okay, so do you see this expense here? Yeah, that's the private school for the twins. So you can add that back in. And over here, that's the computer that I bought my wife, and she doesn't even work in the business. So you can add that expense back in, right? Because you're not even acquiring that, right? Like she's keeping her computer. Okay. And so they start showing us all these personal expenses with company funds. And that's fraud as well. And then I get the question a lot in this class is, but Terry, doesn't everybody do it? Doesn't everybody skim off the top or pay for personal expenses with company funds? And then I hear my mother in the background, I swear, you know, like she's going to haunt me for this all the time is, well, if everybody jumped off a cliff, would you? I mean, can y'all hear your mother saying that? I can remember that from like grade school. Yeah. So here's the reason why not everybody does it is because of the consequences of it. The first consequence is that the value of the business decreases. So when you thought you were going to get paid for your business so much per times EBITDA, and that EBITDA takes your business down from 3 million to 2 million or 2.5 million, your cost, the purchase price for your business just went down because the buyer can't get a loan based on what you say you make. They can only get a loan based on what you tell the IRS you make, because that's what the bank is going to use. And so that they're going to find the value of the business is not what you say it is, and they're going to have to renegotiate that purchase price. And I've seen it over and over and over again. The second consequence is that if there is an IRS audit, and you have to know that there likely is going to be an IRS audit because the IRS needs money, right? Because we have this huge deficit. So the IRS has been going back through things and seeing if they need to audit various businesses. And so if there's an IRS audit, they are going to they're going to find all of these personal expenses. They are. And then they're going to charge you penalties and interest on those, on that income that shouldn't have been counted as expenses. And here's the deal. If it's egregious enough, they can go back to the very beginning of your business. So let's say you've had your business for 20 years when you finally get audited and you've been doing this, right? And they find it and they say, ooh, okay, well, we're going to go back because it's very egregious. It's a lot. Okay, so what happens is, Have you ever noticed on the IRS website when you say, "Oh, how long should I keep my financial records for the IRS?" Right? You know, like my tax returns and all of that stuff that was compiled to get the tax return done. How long should I keep it? Well, the answer is 7 years. On their website, it says 7 years. But then, like in little bitty font below it, it says, unless there's fraud, and then forever. Oops. And I have never encountered anybody that goes, I'm committing fraud against the IRS, so I'm going to keep my financials forever. Yep, because I'm committing fraud. No, instead, as soon as the 7 years is up, they're like, oh, good, I can get rid of this box. I don't want it in my attic anymore, or it's taking up space. Let's get rid of it. And they shred it. And so basically what happens is if they decide to go back to the beginning of time of your business or go back further, you're not going to have the documents to prove that, hey, I didn't start taking all this out until I was fairly successful. So that was probably 8 years ago or 5 years ago, right? And so what they're going to do is they're going to say, you underreported your income by, say, 8% every single year, and they're going to extrapolate it back to the very beginning. And you're going to be paying penalties and interest from the very beginning on 8% of your revenue. Yeah, not good. Now, the third consequence is that there's a piercing of the corporate veil. And what that means is if you're sued, and I would love to say that you're going to be in business for 50 years and never, ever, ever be sued. But the reality is the more successful you are, the more likely you're going to bring in and attract what lawsuits. It just happens, right? It just happens. And so a good litigator is going to allege some sort of cause of action that provides for penalties against you, that provides for various damages that allow them to get into your books because they're trying to figure out what your punitive damages would be. And punitive damages are not like, oh, well, I was damaged $100,000, so pay me $100,000. Punitive damages are how McDonald's ended up with such a huge judgment against them, how Pinto, the Ford Motor Company for the Pinto, right? They ended up with that against them, right? Because it's there to punish you for being a crook or for not acting as a reasonable person would be. And it has to be pretty egregious, but they're still going to look and they're going to allege it so that they can look. It's not necessarily all the time to punish you. They're going to allege it so that they can look at you, get a peek at your financials. And then they're going to find the payments for the twins' private school and things like that. And they're going to start questioning all of that. And then they're going to go to the judge with this. They're going to say, hey, judge, I know that they formed an entity, so they're not liable as the owners of the entity. However, you need to pierce the corporate veil and let us get to their personal assets because they look at all these personal expenses that they did. They're not treating the company as its separate entity. They are treating the company as their own personal bank account, and therefore we should be able to get to their personal assets. And the judge is going to go, yep, absolutely, pierce the corporate veil, and then you're personally liable for whatever is found liable by that judgment, if they get a judgment against you. So it's just not worth it, right? It's not worth it. You need to follow corporate formalities. What are corporate formalities? Well, if you have a corporation, you have to have a president and a secretary appointed. They can be the same person, but those two positions have to be filled. Okay, so what else? Well, you need to do business at an arm's length, right? Meaning that you do not treat your business as your own personal bank account. There's no buying a fur coat for your wife with the company funds. If you go out to lunch to entertain a client at the Palm, you don't go over to the petty cash and say, oh, I'll get $200 or $400 out. I know the Palm's expensive, so I'm going to get that out for the lunch and not put a receipt in. Instead, you need to keep accurate records. When you go to lunch and entertain a client, even if you just write at the top of the receipt, this is what I do. I write at the top of the receipt what it's for and what the tip was and everything. And then I turn it in. I put it in a shoebox. At the end of the month, my admin goes through the shoebox and categorizes everything and does the accounting for it, right? Now, you treat your business at an arm's length. So you do what you would require of your employees to do. So what would you do? They have to turn in a receipt with an expense report, right? That's what your secretary is going to end up doing if you do the shoebox method like I do. But at any rate, receipts, attach it to an expense report, reimburse yourself with a company check, right? That's how it's done. So you want to follow those corporate formalities. Now, if you have a corporation, you must have a meeting of your board of directors and your shareholders at least once every 13 months. If you have an LLC, it's not required, but it's recommended that you have meetings of your managers, right? So that's pretty much it for that. Okay, so assumed names. They are names under which an entity is doing business other than the registered name. Now, you don't have to file it if you have an entity and you're doing business under that entity name, right? And the penalty is that you can't sue, and you may also have personal liability if you're doing business under an assumed name and you're not using, you haven't filed the assumed name. What's the purpose of it? Well, people will tell me, oh, nobody can use my name because I filed an assumed name certificate. Nope, that's not it. You file in the Secretary of State's office if you have an entity. If you're a sole proprietorship or general partnership, you file in the county. Okay. It used to be you had to file 2 locations if you were a corporation or an LLC, but you don't have to do that anymore. Now it's just the Secretary of State. So what is an assumed name certificate? Well, it basically says, hey guys, I'm operating as like let's say you have a Taco Bell franchise store, okay? Well, you can't actually go get Taco Bell LLC. It's kind of taken, right? There's a trademark issue there. So instead, you file Terry's Restaurants LLC, and then you file a assumed name certificate that says Terry's Restaurants LLC is doing business as Taco Bell store number 268. Okay. So what that does is it says, hey, if you get food poisoning or something and you need to sue Taco Bell store number 268, here's who you serve with the lawsuit. Because it's only informing who the registered agent is for that business that's operating under that name. Now, if you have a website, let's say you're Terry's Restaurants, but that was taken, so you're doing it as terrysrestaurantstexas.com, okay? That's not an assumed name because I can put on the contact us part of the page who the entity is. Right? And at the bottom, the copyright symbol at the bottom also is who is that entity. So those are things that the assumed name is used for, but it's not used to protect your name. And we'll talk about that in a little bit. Okay, so how do you minimize liability? First, form an entity, get insurance, right? And we talk about all of those types of insurance at my other class. And then work with your attorney because we're there to help you minimize your legal liabilities. That's what we're there to help you with. Okay, I used to say sign-in forms, but y'all don't really have those anymore because this is Zoom. So if you would send like an email or something to Betsy, she's the one that sent you all the documents for tonight. So just respond to her and let her know how you liked this. If you have any suggestions for improvement or whatever, that's great. We don't have any feedback anymore because we're Zoom. Okay, so let's talk about intellectual property in your business because this is a very valuable aspect of your business. And there's 4 types of intellectual property. The first is trademarks. It's anything that gives, identifies your business, identifies the source. So if you look at that Coca-Cola bottle, the script, nobody in the cola industry can use the script. They have trademarked the script, the words Coca-Cola, Coke, it's the real thing, that tagline. They've actually trademarked the shape of the bottle. They've trademarked the colors red and white. And that was a big issue because there was in the 50s, Dr. Pepper was, in the 40s, their logo was red, green, and white. And then in the 50s, they dropped the green and they just went to red and white. Now they're maroon and white, but back then they were just red and white. And Coca-Cola, oh my God, they were really quick to file a lawsuit. But the problem was they hadn't adequately protected their trademark, and they only trademarked it in the cola, right? And so Dr. Pepper proved to the Supreme Court that they weren't a cola, and they won the lawsuit. So you got to be very careful about how you go about filing your trademark, because you want to make sure that you're adequately protecting it within where you're using it. So at any rate, let's see other stuff. You go up into the attic and there's this pink stuff laying everywhere. What is that? That's fiberglass insulation, but it's that pink, the color pink identifies the source as Owens Corning fiberglass, right? Owens Corning is the manufacturer of it. That identifies the source. Now, if in the production of fiberglass insulation, it naturally turned pink, they wouldn't have been able to get the trademark on it. So now, how does this apply to your small business? Well, the first is that you want to make sure when you're choosing your product name, choosing your business name, choosing your slogans, choosing your logo, that you're not infringing on someone else's trademark. So the first thing, and this is something you can do, okay? So as you're trying to figure all that out, you search the trademarks. So you go to uspto.gov and you search. Just search for the live ones. Don't worry about the dead ones. We're not concerned about the dead ones at all. So you search for that trademark and something comes up. Well, okay, let's see what it's in. Is it in the same class description as you? Because here's the deal. The standard is it confusingly similar to the consumer? So we have Baker Brothers, and it's a deli. But we also have Baker Brothers, and it's a plumber. Oh my gosh, how is that not trademark infringement? Oh my gosh, they're using the same name, right? But no, because no consumer that's reasonable is going to walk into the deli and go, oh my God, my basement's flooding. What are you doing with sandwiches here? Go fix my basement. And no one's going to call up the plumber and go, corned beef on rye, because they're two separate industries, right? So that isn't a trademark infringement. So even if you find something, don't go, oh, it's taken, because it might not be taken in your industry, right? So that's why a lawyer will help, but you need to do this research yourself first, because it might be, and then you're like, well, I just wasted all this money with a lawyer trying to figure this out. So figure it out for yourself first, and then the attorney will help you to figure out if it really is available. But most of the times, my clients, when they come to me for a trademark, they've already done the research, and I can just do a very quick search and confirm that it's available. Make sure they haven't missed something that I knew to look for or something. Now, the trademark searches by state, I typically wait for till the end because it's a pain in the butt to do them. And there's a database that costs money to do the search with that your attorney can do. So that's easier. But then you search common law trademarks. And when I say Google, Bing, DuckDuckGo, Yahoo, Dogpile, Yippee, all of those, do them all. Because the algorithm for Google and DuckDuckGo and Yippee are totally different. So put it in quotes if it's more than one word and do a search and see what comes up. If it's a common word, you may have to actually put some industry markers in there as well, but see what comes up. If nothing comes up that's conflicting, you're okay and you go to the next step. And that anywho.com is a state-by-state, you have to do a state-by-state search. It's basically the yellow pages, because believe it or not, there are mom and pop shops out there that still don't know that there's an internet, or they certainly don't know how to use it. And so that's going to find those for you. Okay. So once you've done that search and you know that it's available, then let's protect your trademark. And you do that through a state common law trademark first. That's the raised TM. That's staking your claim to your state common law. So if you use that mark in any state, it's protected through common law in that state. Common law is not very solid for it, but at least it helps. At least it's a deterrent. Now remember, assumed name filings don't protect trademarks. Now you can register in the state if you're only doing business within that state. So let's say you're an auto mechanic in Dallas and you don't do business outside of Dallas. Well, then you wouldn't qualify for a federal registration. So you would need to get a state registration or just use the common law. Okay. But if you do business between the states, that's like you sell into Oklahoma or Arkansas or something like that, then you would qualify for federal registration. And just count on the $275 fee. Sometimes we can get $225. It just depends on the filing method, et cetera. And that's per class. So if we need to file in 2 or 3 classes, it's per class. So it's going to be more costly. Know that you can actually have your trademark last forever so long as you use vigilance to protect it and so long as you continue to make your filings. So your initial filing is going to last 5 years basically, and you have to, between the 5th and the 6th year, you have to file affidavits and of course pay a fee because they always want their fees, right? But you file that and it basically says, hey, USPTO, still using it, right? And you have to prove that you're still using it. And then between years 9 and 10, yep, still using it. 19 and 20, still using it. 99 and 100, hey, still using it. And then you can protect it for that long. Coca-Cola and Dr. Pepper are some of the oldest trademarks in existence as far as like the cola industry, right? But there's others that are even older than that. Okay. Now, it's imperative that you keep a trademark calendar and charts that to keep track of the trademarks that you have and the time periods for renewal. Because the USPTO is going to send you a postcard. And if you've changed addresses and not updated it with them, you're going to miss your postcard. So you want to make sure that you keep a calendar. That's why I have things for 2030 right now, because I filed and obtained trademarks for clients this year. And so that means that in 5 to 6 years, it renews. And then I have other clients that I was renewing something this year for them, like between their 9th and 10th year. And now I have to renew it between the 19 and 20 in 2030 for them, right? So that's on there. Oh, something I forgot. The other thing is, if you do an assumed name certificate, you need to mark your calendar for the month that you filed that, because it is only good for 10 years. So you need to mark your calendar for 10 years from now, for whatever month you filed it in, that you need to refile. As you'll get busy in your business, you won't even remember that you need to file that. So you've got to mark it on your calendar that you have to keep that up. So trademark calendars, assumed name search calendars, those things, very good to do. Okay, find infringers. You have to be willing to send cease and desist letters to possible infringers. And if they don't comply, if they don't go, oh my God, I'm so sorry, I totally did not know I was infringing, I'll stop, then you have to be willing to sue them, or your registered trademark is worthless. If you're not willing to enforce it, it's worthless, because if somebody is using your trademark for 6 years, you lose the trademark, right? Like if you finally decide to sue them on the 7th year that they've been doing it, well, you lose it. Or they can sue you and say, hey, or they can go get the trademark or whatever and say, you haven't been using it for this long, right? So how do you find infringers? Well, Google alerts, daily keyword search, Copyscape, 10i alerts, archive.org, lots of different things that you can use. Know that if you get a trademark, you are going to get a ton of solicitations in the mail that are in the form of invoices. It's going to happen when you form your business too. You're going to get solicitations that are in the forms of invoices. These are crooked companies that are hoping that you are not paying attention and that somebody else is paying your invoices for you. They're processing it and they'll just pay it. Like there's a lot of companies that'll hire companies to process their invoices and pay everything and do the checks and everything. That's a great way of, because you're not watching it, and you'll have money go out the door quicker than you know, because there are crooked companies that will send you invoices in hopes that you will pay it. And paying that invoice, little bitty print, it says, this is not an invoice. Really, it looks like an invoice. By paying this invoice, you agree to the following contract, and then it's on the back. And they'll bill you for like $3,000 to $4,000 for the privilege of them making sure that nobody's infringing on your trademark. When all you have to do is do this, and you'll be aware of it, especially if it's in your industry. Okay, so copyrights. Copyrights are original works of creation. Anything that is expressive, it's artistic, it's it's creative. It's typically like your books, your whatever, but it can be code, it can be like designs, things like that. And it's the form of expression, not the idea that's the subject. So for example, love. Love is the idea. It's how you express it in a love song, a love poem, a romantic painting, or even an architectural drawing. Okay, yeah, the idea is a home, but look at how many different architectural creations of a home there are, right? That's copyrightable. Now, copyrights, as soon as you reduce it to tangible form, you own the copyright in it, and you can use that circle C and the year that it was created, and then put who owns it, right? Now, you can put in parentheses, all rights reserved, that's optional. It doesn't do anything. All rights are already reserved, whether you have that on there or not. I put it on there when I have a very small business name. So it'll be like 2020 LLC or ABC, LLC. Well, that's like tiny, and I want people to notice it. So then I'll put the all rights reserved, because I want a longer line that people will notice. That's the only time I use it. Otherwise, it really doesn't do much. Okay. Now, if you want to federally register your copyright, which a lot of times you may want to do that, like if you're a photographer or something like that, it's pretty cheap. It's $35 to $85 filing fee, depending upon what you're doing, etc. But there are a lot of benefits to doing the filing. Both in trademark and in copyright, you have a presumption of validity or ownership with a federally registered one. And what that means is it flips the burden of proof. Because if you sue somebody for infringing on your copyright or your trademark, if you have a common law copyright or trademark, you have to prove that you own it, like you own that copyright or trademark. But if it's federally registered, the person you're suing has to prove that you don't own it, which is a much bigger burden of proof. So there's that benefit. It also gives you the right to bring a federal action, which is a good benefit. And it gives you an award of damages without actual loss. And so that's important, especially in copyright, because think about it, like, okay, you're a musician. Oh my gosh, you bootlegged my CD. You sold 200 copies of it. Okay, what, a CD's what, 20 bucks? Not a lot of damages there. Oh, you sold 200 copies at 20 bucks. That's $4,000 damages. Woohoo, right? I think I got the math right. I don't know. Don't hold me to the math. But award of damages without actual loss is a whole lot more. That's a oh, you infringed their copyright 20 or 200 times at $1,000 per occurrence, that's $200,000 in damages, pay them. Bigger judgment. So it's much more beneficial. Know that copyrights last a long time, but not forever. Here's what you have to know, because this affects your small business. If you hire somebody as an independent contract or an independent contractor, and they are not your employee, and they are doing something creative for you, like your logo or creating your website or whatever it is, if you do not get an assignment of the copyright from them, you don't own the copyright. And I get all these people that go, oh, but work for hire, I paid them, work for hire. Nope. Work for hire is a very narrow statute. It's on the next slide. I'm not even gonna go over it because it's so narrow. It's like 9 things. If it doesn't fall in within those 9 things, you don't own the copyright, okay? So then you have to get an assignment. When in doubt, get in the assignment, and you should always be in doubt and get one. Always get an assignment of the copyright. And I gave you an assignment of the copyright in that link. So if you haven't gotten that yet, make sure you download it. How do you find the infringers automatically? The stuff that I put, sorry, I didn't notice that until later. So these finding infringers, the Google alerts send you emails that say, hey, somebody's using that. So if they're on the internet, you're gonna find them, right? Copyscape is duplicate content of your site. 10i is uses of your photos. Some of those can be expensive, so you may not use those immediately, but you just are vigilant about it, okay? All right, going back to this. Okay, so know that you have to get that assignment of the copyright, because if they're not your employee, you don't own it. Now, if you hire somebody as your employee and it's within the scope of your business or a scope within the scope of their employment, it's automatically considered work for hire and you don't have to get an assignment. But let's say your janitor is really good at drawing things, right? Well, and you look at a drawing that they've done of some bears and you're like, oh my God, I'm going to put that on our website because that just fits with our theme. Give the guy $500 bonus because he deserves it, because that's a brilliant bear, and get an assignment of the copyright, because janitors, their job description doesn't include doing artwork for your website. So you want to make sure that you get an assignment of that copyright and you own it. If not, he can sue you for copyright infringement for putting it on that website. That's why you have to be very, very careful when you're doing your website, that you either have a photographer take all the photos that you use and you get an assignment of the copyright from that photographer in those photos, or if you're using something like Getty Images or whatever, that you buy the rights to those photos. I have seen it over and over and over again where somebody pulls an image off of the internet, puts it on their website. Photographers are using that 10i to find uses of it, and they get a cease and desist letter from the photographer's attorney demanding $10,000. I had a client do this year. We settled for somewhere between $5,000 and $10,000. If she had just gone and gotten the license for that photo, it would have cost her, well, actually, I think she could have got a package deal of like 100 photos for like $90. I mean, really, that's amazing. But yeah, there's lots of photographers that are making a lot of money doing this. So make sure that you get that assignment of the copyright, or that you get a license if you're doing that. Okay. So there's another question. We did not, okay, yeah, you did. It's not in the email, it's up at the top. of the chat. Go to the link at the top of the chat. Okay. Patents. Patents, there are two different types. Remember how I said common sense business lawyering, right? This is my favorite patent, because I've never seen it on the market, and I doubt you have too, but somebody thought that it would be really fun if, and a great product, if when you went to the ball game, sports arena, whatever, and you ordered your hot dogs and you ordered your beers and everything, and you know, you go to you're like, oh, you're getting it for all four of you, and people bump you and your beer spills and you've got ketchup all over it, or maybe nacho cheese, and then everybody gets theirs because you're at your seat. You turn that upside down and you make a spirit hat out of it. See where it says 36, that little, yeah, that's where you're supposed to put your team name. Seen that on the market? Nope. The reason why I bring this one up is because common sense business lawyering would have had that patent attorney say, interesting concept. Have you done a marketability study on it? Because if you haven't done a marketability study, you might want to do that. I really think you should do one of those. And that lawyer would have saved him so much money. Instead, $17,000 to $20,000 to get a patent. He's got a patent to his name though, and some people want to be able to say, I have a patent to my name. And then the next question that people say is, well, have you sold anything? No, because who would buy that? Like, I don't even know bald guys that would do that. You know, who wants nacho cheese all over their hair? Anyway, so types of patents. I'll answer questions at the end. So I'm going to just speed through this if I can so that I get y'all out on time. Okay, so utility patents protect ideas. They have to be new and non-obvious in the light of everything else that's out there. They last a long time, 20 years, but not forever. So if you want this to last a long time, you may want to choose trade secrets instead if it's applicable, or you may not even care. Know that if you're an inventor, you need to get NDAs, confidentiality agreements, with anybody you talk to. If you go over to your neighbors and you say, hey, I'm thinking about, I got an idea for a product. Can I run it by you? Get a confidentiality agreement, because if you don't, you've started a time clock ticking. You have 1 year to file from first public use or publication. And publication is telling somebody else your idea. And you've lost all rights for any foreign areas to file, any foreign countries to file and get a utility patent in. Just know it's expensive and it's time consuming, and sometimes it may be better to be first to market. And when I say expensive and time consuming, I'm meaning it's expensive to get the patent in the first place, and then you have to actually file maintenance fees of $2,500 to $3,500 every couple of years. So it can be very expensive. It can be worth it. You just have to do that analysis. And that's why you need a common sense business patent attorney for that, to help you with that analysis to see if it's worth it. So for example, it's better to be first to the market sometimes, like the pet egg. Guys, if you need to know what it is, somebody actually went, they were probably like grating cheese one day, and they had really bad calluses on their feet, and they went, if I miniaturize this cheese grater, I bet you I could get calluses off my feet. And so it's literally a cheese grater for your foot to get the calluses off your feet. At any rate, did the pet egg care about getting a patent? No. Why? Because they were first to market. They infiltrated the market with these infomercials, and everybody scrambled to buy the pet egg because they didn't want calluses on their feet. And by the time Dr. Scholl's, who was a competitor, caught up, it was like 2.5 years before they got a competing product out on the market. Because a lot of times those big companies, they're just slow to move. They're slow to develop. They're slow to test the markets and things like that. And it takes a while. Sometimes it's just better to be first to the market, because by the time Dr. Scholl's caught up, Pet Egg was on to their next latest and greatest, which you don't even have to put any elbow grease into it now. No, 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 no cheese grater for your foot. Now they have a thing that you push a button and a barrel spins and it's got diamonds on it, like diamond dust. And that's going to take off all your calluses. So then they were selling that. If you look at like the Snuggie, like, you know, every year they came out with a different concept of the Snuggie, right? Okay. Design patents. These are a little different. They also have to be new, original, and non-obvious, but it's more the ornamental design or how it looks, where things are, where are the buttons on this? Like, you know, well, this is kind of new and or this isn't new and non-obvious, but like if nobody had ever done a remote controller before, where are the buttons? How is it sleek? How does it look? That type of stuff. It's the appearance, not the function. It's easier to get, it's cheaper to get, and it's only valid for 15 years from the date it's issued. But these patents allow you to exclude others from making, using, marketing, selling the design or selling the product, right? The design patents are cheaper to obtain and they don't have any maintenance fees, so they're a lot cheaper. Okay. If you're an inventor, go there because that helps. They work with inventors. Okay, and it's like an organization that helps inventors succeed. Okay, last intellectual property is trade secrets. They're any formula, pattern, compilation, anything that gives your business value because it's not known or easily ascertainable to anybody else. So the formula for Coca-Cola is the most heavily protected trade secret in the world. Why? Because if everybody knew the formula for Coca-Cola, we'd be making it home for 10 cents a can instead of paying $1 a can. See the value? Well, maybe you're not the next Coca-Cola, so how does it apply to your small business? Well, your customer lists, your vendor lists, your business plan, your marketing plan, all of that is a trade secret. You can have the methods by which you do business, the way you calculate things, all of that can be trade secrets so long as it's not generally known to the public or easily ascertainable. It has economic value and it's maintained in secrecy. It gives your business value. So yeah, okay, I could probably figure out who your customers are, but what I don't know, it's the compilation of that information, right? So I don't know that if I call up, or if you call up Susie and you say, hey, Susie, you want to buy some widgets? She goes, no. But if you call up Susie and you say, hey, Susie, how are those two adorable twins? Your grandkids? Oh my God, you're kidding. They're already walking? Wow, that's kind of early. Oh yeah, it's about a month early. Yeah, wow. Oh my gosh. And you keep talking to her for about 10 minutes about these grandkids. And then you go, oh my gosh, I totally forgot. I was calling because I've been noticing, you know, y'all have been buying widgets from us for a year now to try them out, right? And see how they're going to sell. And y'all have been selling about 10 a month on average. But because of some of our marketing efforts and all, y'all are actually starting to run out of our product by the end of the month before. And I would hate for your customers to not be able to get this fantastic product from us. So I really think that you need to step it up and order 15 a month right now. And then let's check back in a couple months because I'm pretty sure we're on the way for y'all to sell 20 of them a month. And she goes, oh, you're right. Oh my gosh, I hadn't even noticed we've been so busy. Okay, yeah, let's put us down for 15. And, you know, just remember to call me back in a couple months and we'll see where we are. Compilation of information. As long as your competitor doesn't know all that, that's a trade secret. That's the value. That's why you want to keep that. And if you have a Rolodex out on your desks, or if you have the virtual Rolodex, which is your phone, and it is not password protected, that's problematic. If you don't have your file cabinet protected, locked, right? And anybody can get in it, that's not protecting it. That's not using vigilance. If any of your employees can get to all of the information on your software that you run for your business that does inventory control and all of this other stuff, you're not adequately protecting your trade secrets. Your employees should only have access to the information they need to know in order to do their job. Now, it doesn't always have to stay a secret either. So let's say like Michael's, okay? Every time Michael's goes in a location, what goes in across the street? Hobby Lobby, right? So if Michael's is like researching and figuring out where to put their next door, it's a trade secret. When they go and negotiate with the landlord to put in their next door at a location, it's a trade secret. As they're building out and they're hiring all these contractors to build out, it's still a trade secret where their next location is going to be. It is not until they put up the sign saying now hiring, coming soon, Michael's, that it becomes public knowledge and is no longer a trade secret. Why is that important? Because they get up and running. They've been running a year as Hobby Lobby is scrambling to get the place across the street or down the street just a little ways away. And because your rent roll is based on traffic to the area and Michael's contributed to building that traffic up, Hobby Lobby now is going to pay more in rent than Michael's is for at least the first period of rent, like first lease period, lease term. So, and Michael's is building up customer loyalty now because we're creatures of habit and we don't like change. And so what's going to happen is after going to Michael's for a year to get our craft supplies, do all of that, we're going to go over to Hobby Lobby and we're going to check it out. And we're going to be like, yeah, I don't really like the way the layout is, or we're going to find something. We're going to go back to and the only time we're going to go to Hobby Lobby is if Michael's doesn't have what we're looking for, right? We're creatures of habit. That's why it's so important. So that's an example of a trade secret that no longer is secret, right? Because it was disclosed to the public. Okay, so how do you protect your trade secrets? Confidentiality agreements, non-compete agreements, employment and independent contractor agreements. Those are all very helpful and they're all enforceable in Texas. Don't let somebody from California say they're not enforceable. Non-competes are enforceable in Texas. They're not in other states sometimes, but they are in Texas. Okay, before we get to financing the business, I'll tell you that a lot of people ask me, who would you use for this, right? Who would you use? Because all of y'all as entrepreneurs need the same stuff. You all need a logo developed, a website, a banker, a CPA. You all need all of that. And so people ask me all the time, who would you use? And after this class, people will email me and say, who would you use? Who do you recommend? I'm happy to make recommendations. That's totally fine. If you email me, just send me an email that says, send me your referral list, because I finally I was spending so much time referring people that I was like, I need to just create a referral list. So I have everybody that I refer on a list and I don't take any referral fees. It explains why I have confidence in everything that they do. I've got a great real estate broker who goes above and beyond. That's what I gauge by good customer service and they know their stuff. So I'm happy to provide you with my referral list. Just email me and say, please send it, okay? My email is plastered all over the handouts and all, so easy to find. Okay, gonna cover financing the business pretty quickly. The first thing for financing the business is check your credit score, because check your credit reports, because 75% of all credit reports have at least one error on them. And get the credit rating as high as possible. Bad personal credit equals bad business credit. So if you're going into business with somebody and they have a low credit score, that's when it's really important to talk to your attorney, because they can structure it so that that credit score is not a problem in the business. The person won't have ownership in the business, will have phantom ownership instead. But that, and we'll also talk to you about getting them into Dave Ramsey or something like that, so that they can learn how to manage money better, because if they have a bad credit score, it's going to translate into other things in your business. Okay. For example, one of my clients came to me after they'd already formed the business, and they were doing an acquisition, and it took them about 6 months longer to do the acquisition than it should have, simply because of that bad credit score, because the bank was like making them jump through millions of hoops in order to get the loan for an SBA loan. Okay. And even then, they acquired the business and they needed a specialized form of insurance. First quote they got was $100 a year. Pretty good for that specialized insurance, until the underwriter ran their credit scores, saw the low. It was like, I think they had like a 520 or a 580. And then the other one was, no, it was a 520 and a 780. So the 780, great. 520, not so good, right? And so the underwriter ran the credit of both of the owners, and he was like, I'm not underwriting this because of this low credit score. So they had to go back and put it out for bid, and the next insurance company that would underwrite it, it was $500. Okay, so $400, big whoop, but it kept happening over and over and over again. And so that's problematic, right? Because it kept being expensive all the time. Everything that they did was more expensive because of this low credit score. So you want to get the credit score as high as possible. Now, once you do that, you need to figure out how you're going to fund your business. And if you're not funding it on your own, that's when all of this comes into play. So I get a lot of people that will say, like, I'll say, well, how much do you need to start your business and all? And we'll discuss realistic numbers, not what they actually think it's going to be, because they always think it's lower than it is. And so we'll start talking about it. I'm like, well, how much are you putting in? And they'll go, I don't have any money. I've been out of work for a year or whatever, right? Especially now with COVID, people are down on their funds for some of them. And if you aren't putting money into the business yourself, you won't succeed at getting investors in your business, because you have to have skin in the game. Why would I give you money and invest in your business if you don't even believe in your business enough to have skin in the game and invest in it yourself? Put your money on the line. So what do you do if you don't have geez, Terry, I don't have any money. I don't have enough money to do this. I've got to get investors. Well, then you've got to start with the first round. That's the 3 F's. Friends, fools, and family members. They're the ones that put money into your business. It's going to be a small amount. It may be 20 or 25,000, or it may be 5,000. They may either give it to you outright and say, here, I believe in you. Or they may say, I want some ownership, but don't give me that much. That's no big deal. Or they may say, here, I'll give you a loan. Pay me back when you can. And it's a bridge loan. That's the 3 F's. Those people are doing it because they believe in you, not because they want to make money. And that's why they're so important, because that's how you get skin in the game. Now, the second round is angel investors. That's Shark Tank. Shark Tank, watch it. It's actually accurate. A little bit made for TV, but it's accurate. And a lot of times, angel investors will do a percentage of gross profits with an equity kicker. You'll see that on Shark Tank. Mr. Wonderful does it. He'll say, I'll invest in your business. I want 20%, but I also want $1 for every product you sell. That's a percentage of gross profits. The reason why they do that is angels are looking for at least a 16% return on their investment. That's a high rate of return. They're also looking for, to get out of their investment in 3 to 5 years, they want to make their money back, right? 3 to 5 years. Well, how do they make their money back? You sell the business, you give distributions, or you go public. Those are the 3 options. That's it. Well, most entrepreneurs are not looking to sell their business in 3 to 5 years. Most won't be going public in 3 to 5 years. So the only other way to do it is through distributions, and you're not required to distribute out to your owners. So they have to contractually, that's why they do the percentage of gross profits, is to get you to contractually agree to make distributions. Now, the third type of financing is venture capital, also known as VCs or vulture capitalists. They put in more money. Angel investors are going to do a couple $100,000 max, right? Sometimes you might get them together and they might do $1 million or whatever. Venture capitalists are going to do $1 million, $2 million, $5 million, $300 million, whatever is appropriate for what you're doing. But they're also going to want more control in your business. They're going to want a seat on your board. Whereas angels, you're just like, could you please be an advisor? Like, you're begging them. Venture capitalists are like, by God, I'm going to be on your board. And they're going to look at who you have in the company as far as, officers, et cetera. And they're going to look at it and they're going to say, I don't like your CFO. Fire her or fire him and put this person in. And you're going to go, okay, because they're giving you $5 million or whatever it is. Bank loans typically only come into play if you have 2 years of operations and financials. Then banks will consider loaning to you. So as soon as that happens, like I said, try and get that revolving line of credit so that you can draw down on it. Factoring, expensive, but a way to do it if that's necessary. So that $100,000 that I was talking about from Nordstrom, what a factor does is they buy that invoice from you, that $100,000 invoice, and they give you the $80,000 so that you get that early on and you can afford to make the baby clothes, right? If you don't have that cash flow for it. And so you have that going forward. Now, when they collect the invoice, you might get something back between the 80 and the 100,000, depending upon how your contract is. But it's a pretty expensive way of that, and credit cards are your most expensive way of doing business. So those are the way to finance the business. But what the moral of this is that you need to know is anytime you're giving away ownership in your business for value, cash, assets, anything, work, sweat equity, anything like that, that is a securities law transaction, and you have to comply with our securities laws in the US. Therefore, you need an attorney to help you with this. Don't just be giving out ownership in your business without having an attorney do the work to ensure that you are in compliance with the securities laws, because you do not want to run afoul of the securities laws in the US. It can be very problematic. But what's worse is if you don't follow it with the first round of financing, it can affect every single round of financing after that. And I have seen transactions where they screwed it up in the beginning with the 3 Fs, and the angels came in and looked at it and said, oh, nope, not touching that with the 10-foot pole. Or they screwed it up with the angels and the VCs said, nope, not touching it, because of the problems that were created because they didn't go to an attorney to do the investments and ensure that they were complying with the securities laws. Okay, so the last thing I have to cover is, if y'all have, hopefully you clicked on that link and downloaded the copyright assignment. So I wanted to kind of go over that. Basically, there's a couple of blanks to fill in. I also gave you what the signature block for like a sole proprietor and independent contractor would be versus a company, so that you have those. But the most important blank on that, it's pretty self-explanatory, but the most important blank is the one that's like the blank for the last paragraph. So basically it says, you know, we hereby agree, you know, all, shoot, I should know this. It's been a long day. Sorry. I've been up since 4 o'clock this morning. Anyway, so my brain is, you know, when you get old sometimers, and sometimes it just doesn't get there. But anyway, it's for good and valuable, got it. For good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged. We're preparing that for litigation so that the person that's assigning it to you doesn't go, well, you didn't pay me for it. Really, you acknowledge that here. Yeah, but it wasn't enough. Really, it says it's good and valuable consideration and it's sufficient. Okay, so keep going. For good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, blank, which is the person assigning it, the person that created the whatever it is that's being assigned, does hereby assign, transfer, and convey all right, title, and interest in and to all intellectual property, including all copyrights and other intellectual property, in and to blank, right? There's another blank in there where it said it was assigning it to you, right? So that would be your company or you, if it's you personally that's getting it. But the last blank, that one's the most important. The logo attached here to is Exhibit A. The website design and code attached here, the homepage of which is attached here to as Exhibit A and located at whatever URL, okay? The artwork, whatever it is, a lot of times you can attach it, sometimes you can't, but if it's tangible, you can. You want to make sure that you adequately describe it, because if you give that to somebody on the street, they should be able to adequately tell you what's being assigned. If not, you haven't done your job. And the problem with that is if it ever goes to court, the judge is only allowed to look at the 4 corners of the document, right? You can't introduce what we call parole evidence. And that's, well, what we meant, Judge, was, right? Like evidence to explain what the deal was is not allowed in. He has to look at what the document says and interpret it and decide the case. So you want to make sure that it adequately describes it so that you get that copyright assigned over to you. Now, could I have given you a 10-page copyright assignment? Absolutely. And you would have been like, oh my God, Terry, really? Like, I don't know how to deal with this. This works for what y'all need. It's very basic, but it works for what you need in order to get your logo, a photographer to assign over. And if you gave a 10-page copyright assignment to a photographer, they'd be like, oh, hell no, I'm not doing your photos, right? So you want to keep it simple. So that's why I did that. But that's my gift to y'all for putting up with me for so long tonight. And I know Zoom is a hard deal to deal with. It's just so, it's draining to watch things on Zoom for this long. So I really appreciate it. And if you have any questions, I'm going to stay and answer those. And otherwise, you are free to log off. And I hope that I'll see you, or you'll see me, because nobody ever turns their camera on. But I'll see you at the Employees versus Independent Contractors so that you can learn how to grow your business and what to do with that. Okay, so nope, you do not see it in the chat. So if you go up to the very top of the chat, so you'll have to scroll up in the chat, and I'll try and copy it and put it
Terry,
lower.
maybe I joined in a little late, about a couple of minutes late. It's not showing me in the chat. Yeah.
You might have. So hold on, let me see if I can get over to here.
Thank you so
much. That does, I forgot that it's only if you, so I apologize. Hold on just a second. There you go. That'll give you all the documents to download. So let's see. Did not get the link. Can you send it again? We did not get the link. Nope, I don't see it in the chat. Okay. Thank you very much. Is there any, if you have any questions, just feel free to unmute and you can ask me. Or I can, you can also, like, if you have questions that you want to ask in private or whatever, you can also do that. You can just like email me, that's fine, or call me. Call me next week, not this week. This week is crazy. The only other thing is I forgot to tell a benefit of the SBDC. So those that stuck with me this long get that. As an SBDC client, you get a meeting with the lawyers and the CPAs that are volunteers. We're not paid, we're volunteers, but you get meetings with us for free. Just one meeting per person, like not per, like if there's 3 of y'all, you don't get 3 meetings, but like a meeting with me. And if there's a patent attorney and you need to meet with that, then you can meet with the patent attorney, et cetera. Now, we're not going to do legal work for you for free at that point. That's not what that's for. It's what we're doing is issue spotting for you. We'll talk to you about what your business is and what type of agreements that you need and what things to watch out for. And we'll start to issue spot for you so that you see what you need in your business as far as legal goes, or as far as CPAs go for taxes and things like that. And we'll set you on the right path. That's what that's for. But we're not going to form an entity for you or draft or review an agreement for you, because that's when we take on liability. So, but just know we will sit there and meet with you and answer your questions, because a lot of people just have, how does this apply to me? What do I do with this, et cetera? And we'll do all that with you. Okay.
Do we set that up to our SBA coach? Or?
Yeah, so the way that it works is become an SBDC client. And when you're ready to meet with one of us, and you can say, look, let me know when I need to meet with this attorney or this CPA or whatever, and they will tell you. But I don't want you to waste the meeting, because a lot of times they can answer questions that are simple and then that you have. But like, if you have a question that they're like, oh no, you got to ask so-and-so about that, they'll refer you and say, here, go call that person, and then you'll get a meeting with them. Right now, we're just meeting over the phone. A lot of times I can just do the meeting that way, et cetera. But if you need an in-person meeting, we can always do that as well. So that's a good benefit because, I bill out at $3.50 an hour. So that's a good value. So treat it like, if you go to meet with a CPA or an attorney, treat it as if you're paying for it, because people don't value what's free sometimes, and they'll skip the meeting. And if you skip the meeting and you haven't called in advance to like cancel or something, you lose that meeting. So you want to make sure that you treat it as if you pay for it. In fact, I tell people to treat meeting with the CPA or with SBDC as if they're paying for it too. And literally, when you meet with them, keep your appointments, because it's what you don't know that kills your business, right? So you're actually benefiting your business, even if you don't think you have anything to discuss with them, even if you don't have anything. You print out all of your financials and you take it to them, and they'll start asking you, so how's it going? And you start talking, oh, everything's fine. Yeah, I just fired Joe. Joe, really? You fired Joe? Wasn't that the guy that, oh yeah, we need to talk about firing Joe. Like, that's a problem. We need to figure out how to fix that problem, that type of stuff. Or they'll look at your financials and go, hey, did you know that your profit margin has decreased by X amount? Right? And you're like, I had no idea, because I've been busy running my business. I forgot to check my financials. And so they'll start pointing out stuff. And that's what's important. So then when you keep your meeting, decide what the value is, like $150 an hour or something like that. Most coaches are $250 an hour. Take that money that you would have paid and put it in your vacation fund, right? Because then you have a vacation fund for when you get your business running to where it'll run without you, then you can go on vacations. That's just that's my little tip. That's what I recommend. So, other questions? Anything else?
Wonderful presentation, Terry. I really appreciate your time and teaching us. It's a great value to us, I think.
Absolutely. I'm happy to bore you with legal stuff. I'll be teaching it again in the first week of December. So if you have friends that should take this, refer them, please.
Yeah, sure. And I have a question, like, how do we approach you for our business needs? Like, are you a business lawyer attorney?
Yeah, I'm a business attorney. I can't solicit for, from these SBDC classes.
Got it.
So
Okay.
if you want to call me, just call me up.
Okay.
That
Got
works.
it. Thanks. Yeah.
Happy to help. Anything else? Thank you, everybody. Y'all have a great evening, and hopefully I'll see you at my next class. Take care.
Thank you.